And welcome back to the Law and Crime Network. As you can see, that was just pretty horrifying scene in the courtroom on last week, when the verdict was read in the Shelby Isaac matter. We can see that she fainted immediately. However, the show must go on, right, Jesse?
The show must go on. You don't usually see that happening. We've handled a lot of cases here on the Law and Crime Network. We're also covering the Adam Matos case, and when his verdict was read, he was stoic. But then again, he didn't show much emotion on throughout this whole trial to begin with.
He did not.
But I think she had to be very surprised, given in this case, given the evidence that was against her. You really had a case that was built around one star witness that was the co-defendant in this case, Victoria C. And I don't know. I think she was surprised. She wasn't convicted of first-degree murder.
No, she was not convicted of the first-degree murder, but I would assume that it would still be a shock to her to have been convicted at all. At least she got convicted of the negligent homicide and the criminally negligent homicide of the child or of the baby. But it's just a really unfortunate circumstance. I know that being in the courtroom, usually a judge will admonish the audience before he reads the verdict, letting them know, look, this is a very serious matter. Please make sure that you do not cry or you do not make any loud noises after the verdict being read. And yet we have, I don't want to say poor Shelby, but we have the defendant here who collapsed on the floor.
And the judge is not breaking a stride.
Does not. He just continues to poll the jury. And I just, without even asking if she was okay, I think that maybe it was just to, I guess, continue on and to not, make a scene out of what happened, but we can hear.
And the juror's like, yes. They're being asked questions. Do you want to take care of what's happening there? No. But she wasn't found guilty of first-degree murder, and I thought that one of the interesting ones is, in this case, and it is a sad fact as it is, but an also interesting fact, is that unborn child was classified as a victim. Now, the jury didn't find that she was guilty of first-degree murder of the child, and I thought that was interesting, and I can't say I'm surprised, because if you kill someone who's pregnant, and we don't necessarily know if she knew that Edwina Thomas was pregnant, so how do you have the intent or the premeditation to kill an unborn child?
Exactly. And, we can go back and forth on this issue. There are some that believe that a child is a child from whatever stage during the pregnancy, and we have others who believe, otherwise. But we see here in this case that the jury members found that something had to be done for the child that Edwina was carrying. So.
Yeah. Well, we know we had that verdict, and we also are covering another special case here on the Law and Crime Network. We're going to be continuing our coverage of the Adam Matos case because today is penalty phase day. The entire day is going to be dedicated starting at around 9:30, 9:45 about whether or not Adam Matos should be sentenced to death. We know the judge has only said that this is going to take one day. There's going to be a series of witnesses and evidence that will be introduced today in this penalty phase. And, Stephanie, I think Adam Matos has brought on separate counsel now for the penalty phase of this case. And I think you see that happen because this is a totally different animal than it was just the trial.
Absolutely. It's going to be a totally different animal. And thank goodness that, the cases are bifurcated, and that you handle one part of the case and then you handle the death penalty phase. And so we have to see here, I really would like to see, I know that we have the witness list of the witnesses who will come up to testify, so we'll be sure to provide that to you as we move forward before the case actually begins today. But we do actually have Sam Braverman on the line with us. Sam practices here in New York and was a former prosecutor, I believe, in New Jersey. Sam, are you with us this morning?
With you. Good morning, everybody.
Good morning. How are you?
Thank you. How are you two?
Well, thank you so much for asking. Now, before we get into speaking about the Adam Matos trial, which is set to begin the death penalty phase today, I want to talk a little bit about what occurred in the Shelby Isaac trial last week in regards to her fainting. Had you ever experienced anything like that before, being in the courtroom?
I have. I did a long run where I did murder trials for about 5 or 8 years and adjusted those kind of cases. And of course, as you can imagine, those unraveled the largest of personal emotions and the conflict between the parties and the state and the judges and the juries. So it does happen. I've had two that were similar to this, and just to attach to points that you'd raised, one about the chaos that comes from a complete dissembling of the people in the audience, and the second one's about the polling of the juries. If we'll start with whichever one you like, but let's start with the one about the coming undone. I had a case where there was two defendants, an older one and a younger one. I had the older one, who was kind of generally believed to be the person responsible for the murder. and he didn't take a plea, so the co-defendant didn't get a plea. And then with the verdict, which convicted them both of murder too, the mother of the younger defendant leapt up out of the audience and screamed, "You murdered my son too." At which point the court officers come flying in, there's total chaos, and it is that sense of you're in the middle of an actual riot. You don't know where to look, you don't know where the punches are going to start to go, you don't know, are they going to tackle your guy, are you next to your guy? The judge has got that face of horror, the jury's got the face of horror. It's quite chaos, to be sure.
Sam, let me ask you a question. I'm sure people wondered this. Was it an act, or do you think it was real?
Oh, I'm sure that both are possible in equal measure. There is a whole lot of drama that goes on to these sort of things. You know, when people are posturing for a certain particular effect, you know, the clothing that they wear and the body posture that they wear and all the things that witnesses for the state and for the defense alike are all thinking about, it's not impossible for me to imagine that this is an act. On the other hand, it is, if you imagine the moment when the judge says, and how does the jury reach guilty or not guilty? In that moment, the defendant is either going to spend the rest of her life in prison or die or go home. And if you think about that moment at which you would be standing, you can imagine it would unravel just about anybody.
Correct. And I think I noticed in the beginning when she actually stood for the verdict being read, she had to have the help, I believe, of the attorney to help her up. So perhaps even before she'd been extremely nervous, which is normal, but it was quite a scene in the courtroom. So what we're going to do is, I believe we may have had some issues with the sound earlier. So what we're going to do is we're actually going to play the clip again so that you all all of our viewers, can see and hear exactly what happened in the courtroom on that day.
Our system. We, the jury, find the defendant guilty of second-degree murder as included in count 2. And that's also signed by Ms. Murphy. Is that your verdict, ma'am? Sir, is that your verdict? Yes, sir. Your verdict, ma'am?
Yes.
Your verdict, ma'am?
Yes.
Your verdict? Your verdict? Your verdict? Your verdict, sir? Yes, sir. Your verdict? Your verdict? 3. Verdict reads, we, the jury, find the defendant guilty of criminally negligent homicide as included. That was count 4. I'm sorry, I skipped one. In count 4, criminally negligent homicide as included in count 4. Is that your verdict, ma'am? Your verdict? Your verdict? Your verdict, sir? Your verdict? Yes, sir. Your verdict? Your verdict?
Yes.
Your verdict? Your verdict? Your verdict? Your verdict? Your verdict, ma'am? And in count 3, we, the jury, find the defendant guilty of reckless homicide as included in count 3. Ma'am, is that your verdict? Is that your verdict? Is that your verdict? Yes, sir. Is that your verdict, sir? Is that your verdict? Your verdict? Your verdict?
Ladies, come on.
Well, ladies and gentlemen, thank you for your time and attention this week. I know it's been a hard week for all of you.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber with Stephanie Willis. Just saw the verdict in the Shelby Isaac case, which is what we were talking about before. We have with us right now Sam Braverman. Sam, let's talk a little bit more about the Shelby Isaac case before we move into the Adam Matos case and the penalty phase of that entire case, which will begin at 9:30, 9:45. Let's talk one more thing about Shelby Isaac. So we know that she was originally charged with first-degree murder in this triple homicide for each one of the victims. She was found guilty of second-degree murder for E.J. Tate. 1 count of reckless homicide for Edwina Thomas, and 1 count of criminally negligent homicide for this unborn child. It's not everything what the prosecution wanted, but it's a lesser charge than what they were initially going to get. What did you make of those charges, what she was actually convicted of?
Well, it's almost like a law review problem. You now have all 4 states of intent or mens rea on display there. The first one, the murder 1, is obviously the intentional killing of the other person. As you work your way down through the list, the murder 2 is probably an intentional causing of serious physical injury with a weapon resulting in death. The reckless is another level down of intent where that you consciously disregard a known risk. And then the negligent homicide is where you do something that a reasonable person would not do, or not do something that a reasonable person would do. So you have 4 different levels of intent there. It seems to me like it's a jury compromise verdict of sorts, where they're thinking that she's clearly culpable for the criminal conduct because it's not another person, it can't be, and that the conduct obviously was extremely serious. But at the same time, they have various different levels of conduct, and that gives the jury the ability to kind of portion out a level of punishment. They may not always know the sentencing. In most cases they don't, but sometimes they do. But generally speaking, that's their way of leveling the playing field. It's kind of an equitable result as opposed to more a purely legal one.
And she faces up to 15 to 25 years in prison for the most serious charge of second-degree murder. And from all accounts, it seems that the prosecutor will ask for at least a minimum of 15 years. So, this is not what the defense thought was going to happen. I think in a case where it was built around really one star witness, the co-defendant in this case, her accomplice. And you see in these cases where it's usually not enough for a jury to convict, but they found enough here, and she's facing some pretty serious offenses and serious punishment.
I would also think that this is the kind of case where the judge stacks the sentences. Because even though it's one criminal event, when you have separate homicides, I would imagine that he would stack the 2 adults. The shooting of the woman causing the death of the unborn child probably merges as a matter of law. So those 2 sentences probably run concurrently because it's one act. Unless she literally went after the infant, or the fetus rather, it seems unlikely that you could survive consecutive statutes there. But I would think for the 2 adults, it's likely to be consecutive. That's common for judges when you have multiple homicides.
Well, unfortunately, this was an unfortunate incident in the Shelby Isaac case, but we had another huge incident that happened last week. We had the verdict reading in the Adam Matos trial, and we found that we all know that he was found guilty. What we're going to do right now is we're going to take you to a clip of the defense's closing arguments, just so that you can be caught up as to where we are. We do know that the death penalty phase of this trial begins today, and so we want to make sure that all our viewers are caught up. Take a look.
Ladies and gentlemen, this case is not the case of revenge that the state portrayed in its opening statement. This case is about self-defense. Adam Matos met Megan Brown about 13 years ago in the state of Pennsylvania when he was 19 and she was 18. They had an on-again, off-again relationship. In 2009, she became pregnant. Adam was thrilled. He planned to be the father he never had. As the birth of the baby drew nearer, however, Megan told him that he was not the baby's father, and she broke up with Adam. But as time went on, the baby looked exactly like Adam. A paternity test determined that Adam was the father. Adam dearly loved and loves his son and wanted to be a part of his life. Be that as it may, this conflicted with plans that the Browns had made. They were going to leave Pennsylvania and move to Florida with their daughter and grandson. They couldn't take Tristan out of Pennsylvania without Adam's permission. They decided to invite him to move to Florida with them. Megan reconciled her relationship with Adam. They were going to be a family. Adam believed that. He helped with the moving. Greg Brown had a bad back. Adam helped unload all the boxes and furniture and contributed to the unpacking and cleaning of the new home. Adam began to feel like he was a part of the Brown family. However, once they moved in, the Browns' attitude toward Adam changed. He had to immediately get a job, and pay $740 a month toward rent and other expenses. If not, he would have to move out. He found a job at Denny's about 4 miles from the house. A kind neighbor gave him money to buy a bike for the commute. He planned to make this work. Within weeks, though, Megan began a relationship with Nicholas Leonard, laying the foundations of a very unstable triangle. Fast forward to Wednesday, August 27, 2014. Megan stayed out all night. Adam, days earlier, found out that Megan had been involved with Nicholas Leonard. Adam was upset, and he did call Megan several times that night. Actually, Adam also talked with Nicholas Leonard on this night. Nicholas texted him, and they talked on the phone 2 to 3 times for about 45 minutes. Adam was upset because Megan had been telling him that she was not in a romantic relationship with anyone. She had been playing constant games with him. They were broken up, and they weren't broken up. During the last week, she would sleep in Tristan's room, but as recent as 2 days prior, she slept with Adam. This is what was going through Adam's sleepless mind at 5:30 a.m. when Megan came home. This is what led to the argument that morning prior to her calling 911. He wanted to know where he stood. Adam had left his family and friends and all that he knew in Pennsylvania to move 1,000 miles to Florida, and all he wanted to know was where he stood. After Adam left the house on the morning of August 28, Megan eventually reached out to Nicholas Leonard. The opportunity arose to eliminate the third wheel. Nicholas armed himself with his loaded semi-automatic Kel-Tec pistol and went over to her house. Before he went over there, he ran into Robert Dunleavy. Robert Dunleavy's father, Ralph, lives in Nick's neighborhood. Robert knows Nick and has worked with him on handyman jobs. Nick was a friend. That morning, Robert saw Nick as he was leaving his father's house. Nick was going to call a cab so he could pick up his truck from the Anchorage bar he was at the night before. Robert offered to give Nick a ride. During the ride, Nick told Robert about his new love, Megan, about her boyfriend who assaulted her. He showed him the gun he had in his pocket, and he told him that he would love the chance to put a bullet in between Adam's eyes.
This first photograph here, can you tell us where this is in the bank?
This is the front door to Wells Fargo.
And is that Adam Matos?
Yes.
Now, the next photo there, is that the same door we just saw?
Yes.
And is this the same door, just the person a little bit farther inside?
Yes.
Now, this one appears to be a different angle entirely. What are we looking at here?
That's the teller line.
And the teller line meaning on the left side of the photo, that's where all the bank tellers are, and then the public approaches from the right side?
Correct.
And is that, again, the Adam Matos who you cashed a check for that day?
Yes.
Now, this photo appears to be a different angle again. Where is this one from?
That's Adam at my window, cashing the check.
And same camera angle here?
Yes.
And is this him actually physically handing you the check?
Yes.
Again, same camera angle?
Yes.
Now here, he's handing you something. Can you tell what he's handing you there?
That's his ID, identification.
Is this next photo also still his ID?
Yes.
here, there appears to be one other card in the screen.
Social Security card.
And is that part of what you sometimes require to cash checks for non-account holders?
That's correct. 2 forms of identification.
And then this photo again, same camera angle, what are we looking at here?
He is thumbprinting the check.
And that looks like, is he actually putting his hand in the ink pad in the photo?
Yes.
And is that him putting the actual print onto the document?
Yes.
Again, same camera angle.
Yes.
And is this the same camera angle?
Yes.
And is that again the same camera angle?
Yes.
Now, is this you actually giving him the cash back in exchange for it?
Yes.
Now, the hands that we can see here, are those your hands?
Yes, they are.
And again, this is the same camera angle. He appears to have the cash in his hand at that point.
Yes.
And this is back to the, I'm sorry, I forgot the word you used for this area.
This is the teller line
Teller
in the
line.
lobby. Yes.
And is that the Adam Matos lead?
Yes.
And this is the same doors we saw earlier.
Yes, they are.
And that's just him leaving this time instead of coming in.
Correct.
And again, the same thing.
Yes.
Now, while Adam Matos was at the bank, did he talk to you about possibly opening a checking account?
Yes, he did.
And did you discuss with him coming back the next day?
Yes, I did.
And when you set that appointment up, did you take his address and his phone number?
Yes, he did provide that.
And when that information is provided to you, did you enter it into your computer system?
Yes, I did.
And, Your Honor, may I approach with what has been marked as state 609?
Okay.
And without showing the jury, can you tell us what this is?
This is a screenshot of the information that I entered into our system of Adam Matos' address and his cell phone number that he provided me.
And is that a true and accurate copy of what you actually entered in?
Yes.
Your Honor, at this time we would like to introduce this into evidence. It states 609.
Any objection?
No, Your Honor.
All right, it'll be entered as 609. Okay, you try.
And may I publish it?
You may.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber with Stephanie Willis, and we are showing you some other earlier clips in the Adam Matos case out of Pasco County, Florida, because today is a big day in that man's life. It is the day, determination by the jury about whether or not they will sentence him to death. We are in the penalty phase of this case, where a whole collection of witnesses will be put forward and evidence both by the prosecution and the state. The prosecution saying that the jury should find him, sentence him to death, while the defense will try everything in their power to see that he gets life in prison without the possibility of parole. I want to talk a little bit about this and what we can expect. We're here today joined by criminal defense attorney Sam Braverman. How are you doing, Sam?
Good, thanks. How are you?
Good. Sam, let's talk a little bit about what the defense might do here. We have a collection of what the witness list is. Now, again, we don't know if they're going to call every one of these witnesses, but it's just an idea of what we can expect. I count at least 5 family members from the Matos family that might testify today. What do you expect? Is that important for the defense to bring in family members of the defendant to show, look, he's a loving family member, he was there for his family? How much does that affect a jury when at the end of the day they just convicted him of a brutal quadruple homicide?
Of course, that's the hard part. And part of it is when you're trying a case like this, you have to decide whether or not you are trying it for guilt or innocence, or you're trying it for the penalty phase. Because they really, sometimes, like as you just posted there, they can be in conflict with each other. So sometimes the theory of defense at trial is you open and close, not in like that you're going to lead this jury to a land of acquittal for your guy, but you're laying the groundwork for the penalty phase if you have a really good sense that you're going to lose anyway. So what these people might do is they're now coming in to try and save his life. And they can do it 2 ways, exactly as you said. Here's a guy and he has redeeming qualities. And if the state executes him, we lose somebody with some redeeming qualities. The flip side is, if nobody from the family came in to say, I love this person, if nobody cares for him, then it's easier to kill him. And remember, that's what the jury's deciding. The jury's deciding, do we have the courage to pull the trigger ourselves? And if you can put up some people to say, I mother, I father, I brother will suffer if you kill my child, then sometimes that may be enough for somebody on the jury. Because remember, the jury selection process for a capital eligible jury is quite detailed. You usually have individual voir dire, you have questionnaires, and you've learned an enormous amount about these people, sometimes on social media and other various aspects of their lives, to see what is going to save one person from that moment of pulling the trigger. And if you can save one juror to say, I will not kill this woman's child, meaning the mother of the decedent, mother of the defendant, then that's enough. It has to be unanimous, remember.
Right. Do you think, I think the biggest factor in favor of Mr. Matos is Tristan, his now his 8-year-old son. The idea that he will be fatherless if you kill Adam Matos. Now, again, from all accounts, and Stephanie, you might have heard this as well, and correct me if I'm wrong, he might have given up parental rights, but at the end of the day, he's his father. So you take a father out of this world who has a son, I think that might play an effect upon the jury. What do you think about that, Sam?
I had an unfortunate case where a guy killed his wife in the presence of their child. So he was going to prison for decades. Obviously, the mother was deceased. And there was some aspect of that at play in the case. The child was 4 years old at the time. So, I mean, it was really catastrophic in every possible way. There is still an element of it. There's still an element of the idea. Now, surely the state would say, well, what kind of father do you want? Is this quadruple homicide father the type you want in the child's life? The flip side of that is, do you want it to be that the child's father, for the rest of the child's life, the child's father was executed for murder, or that the child's father is doing prison for murder, and there's still a chance that in the child's mind, there's something redemptive about that? That's a very subtle play, and you need to have that. That's hard to explain to a jury, and I would imagine you'd have to be really lucky to get jurors to understand that subtle difference between the two.
Right. Sam, so we know that during this portion of the trial, we want to bring out, or the criminal defense attorney would want to bring out mitigating factors from members of the family. What do you think are some of the factors that we could expect to hear from the defense attorneys this morning?
Well, the general kind of catalog of factors that you see in a situation like this is anything that goes to the question, is there anything redeeming about this person? It is almost like the biblical story of Lot and Sodom and Gomorrah. If I could find 50 people, would you save the city? If I could find 5, if I could find 1, would you save the city? This is Lot having the negotiation with God. It's a similar sort of sense in the jury play here. If I could find one reason to keep this man alive, would you keep him alive? I mean, this is life or death. So you're going to these kinds of questions. And so things you might bring out is that he has developed a relationship with somebody else in the world who will suffer, that he can learn things, that his life in prison can actually have deterrent value to other people, that he would be amenable to some of the learning that could happen in jail, that he shows remorse, because we have a belief that remorse is the beginning of redemption. It's part of a larger religious philosophy, it's part of a criminal justice philosophy, that if you plead guilty before trial, you get a better disposition than if you go to trial. So all those things are kind of the ideas that we're going to be positing to a jury.
But what about sorry, Sam, what about the idea that, the flavors of he might have suffered from some sort of mental illness or defect? Obviously, the defense didn't go with the insanity plea, but they can introduce evidence here in the penalty phase that perhaps Mr. Matos suffered from some sort of condition. We kind of saw this in the Luis Toledo case, which we also covered here on the Law and Crime Network, where a guy killed his wife and her 2 children, 2 young children, and the defense tried to point it to the fact that this is a guy who's had multiple injuries to his head. He suffered traumatic head injuries and he suffered impulse control. And you can't sentence this guy to death. He couldn't control his emotions. Do you see that playing into this kind of case?
I imagine that plays into every kind of case. That's standard background evidence. I've actually got a sentencing in a capital was a capital eligible. They ultimately didn't seek it, coming up in December. And when we started this case a year and a half ago, the first thing we did was we lined up every type of expert to evaluate my client, literally medical, psychological, psychiatric, historical, to present that evidence and to give us the background, the fluency in this person's life, to be able to describe it. Because, again, one, you might find one juror on the panel that is persuaded by this evidence. And then the other one is that whether or not it's enough to eliminate guilt or innocence by reason of a mental disease or defect, this is a whole different level. This is mitigation. It doesn't have to eliminate something. It just has to bring it down, that the mitigating factors outweigh the aggravating factors in some way, and that appeals to the juror's sense of fairness. I would imagine that's very likely at this stage.
Sam, thanks so much for discussing and explaining that to our viewers. We do know, and we've received some news that Charles Manson has recently died of natural causes at Kern County Hospital, according to a California Department of Corrections statement. We do know Charles Manson was the cult leader and became the face of pretty much evil across America after orchestrating some of the most gruesome murders. He murdered pregnant actress Sharon Tate and 6 others in Los Angeles during the summer of 1969. We have just received word that he died Sunday after nearly a half a century in prison. He was 83 years old.
Sam, you shedding a tear?
No, I'm not shedding a tear for him. And I don't shed a tear for a lot of the people and the evil things that they do.
Yeah, you know, Sam, it's so funny. I'm just going to say, if anybody wants, on our website, lawandcrime.com, we have a whole article about this. And the picture that we've used is Charles Manson in his later years, and he still has that swastika right in the center of his forehead. I mean, really, it's this guy, Sam. I mean, it's amazing. But evil, I've seen a lot of posts on social media about this, things that I can't repeat on air, but people are not shedding tears at this.
Yeah, but your point is a good one. This actually goes back to the other question.
Right.
Because one of the things is, when you ask a jury, is life in prison enough? Life without the chance of a parole? And the empirical evidence suggests that jurors across the country, by a strong majority, favor the opportunity to give somebody life without parole if it truly means no chance of parole. And Charles Manson, in fact, was one of those guys. He got life without parole. He was not given the death penalty. And essentially the system worked, which is to say that he spent 50 years in prison, 40 and change in prison, and died there. And he never was released. So it's one of those choices that you give to the jurors. And if the Manson case is the poster child for what is the level of evil, you don't want to be in a situation where you're talking about gradations of evil. Is this a sufficient penalty? And the fact is, it did work. He did spend every day of the rest of his life in prison, never released, not to be released. That's one of the choices we give jurors in these capital eligible cases. And so to that extent, it actually shows that the system did work, and that an alternative to executing somebody does exist, can be used, and that's an argument you're going to see in this case.
It's interesting because in the Luis Toledo case, which we also covered and I mentioned before, so this guy put on a whole trial, said that he had nothing to do with the murders. He gets convicted, and the first thing he says after his convictions is, "Please, I want to waive my right to this defend myself in this penalty phase, and I just sentence me to death. Just sentence me to death." Well, you know what's funny? He wasn't sentenced to death. He's going to be facing the rest of his life in prison, and I wonder how much, like as you said, a jury looks into that and says, you know what? How do we make sure that he's punished properly for these crimes he committed? We want to make sure that he suffers, and it's just that he suffers. So what do? We sentence him to prison, the thing that he didn't want, and the thing that he's going to have to live out every one of his days in prison. And some might view that as a worse punishment than granting someone death.
I've been to solitary confinement for people serving life, and it is as awful as you can imagine. There is nothing nice about it. The idea that people are worried that somebody in jail is going to sit around playing pool and crocheting and really enjoying their time, it's not the case at all. It would drive any reasonable person insane. And if you're talking about the people who are, in a certain sense, marginally mentally ill anyway, who commit these homicides, it is really, it's a soft push right off a cliff into insanity. A very hard way to spend the rest of your days.
Sam, What would you expect, I guess, for in this case, and I know that you can't really determine what the jury is going to say or what the outcome that the jury will have today once the death penalty phase of this trial is completed. But in regards to, I know that we were just talking about the difference between a life sentence and the death penalty phase. But what would you suspect would happen today?
I didn't see the jury questionnaires and the voir dire. And that would tell me more than anything else. And probably a lot of the voir dire was individualized and in chambers. It's not uncommon in a death penalty case. So you don't see a lot of it. But this is really one of the best examples of how this trial is won or lost in jury selection.
Sam, you know what? We're going to have to interrupt because we do have a live feed now in the Adam Matos case. The penalty phase will begin. So thank you, Sam, very much. And let's go live.